Well, let's move on to some email questions because Carolyn has an email question and she definitely wants an answer. So I want to make sure we give her an answer to her question. All right, here's her question. My grandma left everything to my dad and my aunt, but my aunt died in 2015, and grandma never updated her will, and now she's in hospice. What will happen with her estate? Now, this is a very popular thing that goes on with people. They have a will and something happens and they never update it. So, Mike, where do we go from here?
Well, as with anything in the law, every lawyer is always like, well, it depends. But and here, there's just a lot we don't know. But what I can do is just answer some general things. And so, first of all, just because she's in hospice doesn't mean she can't update her will right now. I mean, it would depend upon whether, she could have a physical problem that has her in hospice, but still be mentally alert and awake. So that's the first question that comes to my mind: is grandma still capable of understanding enough to execute a new will? And that could be done right there. So if she's not, and I guess I'm assuming that that's the concern, is that grandma can't do that, but it's unclear. If she can't, then that could go a couple different ways. Usually, a will provide for this sort of instance. It'll say in the will, if this person predeceases, means dies before I do, then their share goes to this, that, or the other. And then I believe, I'm no probate expert, if all that fails, grandma can't do a new will, the will grandma's got doesn't say what happens to auntie's share, then I believe it would go to the aunt's heirs. Uh, but there's just a whole lot of unknowns here. It's kind of difficult to answer, but it's a good reminder to make sure your will stays updated when life changes.